Yes, Ms Cahoon.
Good morning, Your Lordships. May it please you, I appear on behalf of the appellants in this matter, and my then friend Townsend appears on behalf of the respondents. Just to go through short elements of housekeeping, you should have 3 slim volumes before you.
Yes, thank you.
One is a core bundle, one is a supplementary bundle, and lastly the authorities bundle.
Yes.
And my lords, I would refer generally to the skeleton arguments that
Yes.
I have produced.
Yes, and we have updated versions of those on both sides, including a few errata kindly sent through by Ms Townsend yesterday, I think.
Yes,
yesterday evening.
There may well be some in mine.
Well, don't worry.
Apologies.
Well, no,
at least we've got some references.
Don't worry at all about
Hopefully
that.
helps.
Yeah.
My lord, the essential facts of this matter are really not complicated, and I don't propose to labour them. Clearly, this is an appeal that deals with a decision by Mrs Justice Lang to refuse permission for the appellants to judicially review the service of a liability notice under the SIL regulations and demand notices that went with it in late September, or mid-September rather, of 2021.
Yeah.
My lords, what I intend to do is divide my submissions into 4 basic issues.
Yes.
The first is that of the SIL regime and the importance of liability notices themselves.
Yes.
And in particular, SIL Regulation 65(1), which deals with the timing of issuing and service of those notices.
Yes.
The second issue I will call the surcharge appeal issue, which is in particular the grounds that are available when someone has received a demand notice with surcharges, what they are able to appeal that demand notice on,
yes.
And the effect of decisions by appointed persons or inspectors who deal with them. Thirdly, I intend to then turn to SIL Regulation 65(8), which is the ceases to have effect point.
Yeah.
And what the effect of a liability notice, a new liability notice, or indeed a revised liability notice is upon an earlier liability notice.
Yes.
And then lastly, perhaps wrapped up, is the arguments that are put forward about the absence of prejudice in this case, whether there has been any waiver, and indeed the application of Section 31 of the Senior Courts Act, and whether, in effect, the appellant would have been in entirely the same position if the liability notices had been effectively served or properly served.
Yes.
So, my lord, what I will do now is briefly go to the facts themselves, but what we can do is look at the decision in Trent, which was Mrs Justice Lang, and that is an authority bundle number 220, sorry.
These are all, for those doing it electronically, they're all hyperlinked, aren't they?
Yes, I believe they are.
We also have them in printed form.
Sorry, I did not mean Trent, my lord, but keep it open. What
Right.
I meant was that Mrs Justice Lang's decision in our case.
Right. You'd like us to have Trent open?
Have Trent open, my lord, yes. Which is at page 73 of 200 of the core bundle.
Right. But you'd like us to go to the judgment, would you, in this case first?
Yes, please.
Where the judge sets out the facts from
Indeed.
paragraph 3 onwards.
Yes, madam. Clearly, this deals with a planning permission that was granted to the appellants. It deals with a site that was bought originally and is set out and explained in the witness statement of Mr Bennett and Mr Brathwaite. It was a site that required some, well, it has contamination on it. It was a previous refrigeration factory. The essential planning permission, however, was a Section 73 planning permission following the initial main planning commission in 2017. I know that my learned friend wishes to draw the court's attention to the earlier history, because there was a liability notice served in 2017. But that, in my submission, is not where the key is. The key here is what happened following a second Section 73 planning commission, which was granted in February 2019, and that's referred to paragraph 5 of the judgment.
Yes.
My lord, in short, there was no assumption of liability notice served by the appellants. That is not required. There was also no liability notice itself served, which is something that is a duty that is on the collecting authority, not the appellant. There is nothing that a person who receives planning permission is required to do in order to trigger a liability notice. That is entirely a matter and in the rest of the charging authority. My lord, some 6 months later, the appellants decided to commence development. It could not wait. As noted at paragraph 6 of the judgment, Mr. Justice Lang says it was common ground that the defendant was required, in other words, the respondent, to serve a fresh liability notice in respect of the February 2019 commission, because there was a change in the floor space from the permission originally granted in 2017. So that is all accepted and is the starting point, as it were. Now, the appellants continue to develop their site based on their planning permission, but it was then in June of 2020 that they were contacted by the charging authority, and the request attached the 2017 SIL liability notice saying, we noticed that commencement's already started. What's going on? And the response was, well, we started in August of 2019. And the questions that were asked, and my lord, those can be seen. The communications are at supplementary bundle, page 107.
Just a second.
Forgive me, 105.
Yes, right.
19th of June 2020. This is a letter to Mr. Bennett, or Melton Meadows Properties, which was a developer company. And it says that on the second paragraph of the letter, obviously, that you can see that you've commenced. The council is now required to issue a demand notice for the SIL liability. So it had at that point considered that the SIL liability notice in 2017 was the relevant liability notice. On the last paragraph, it notes that there had been a Section 73 application, which has changed the floor area, again, which explains why there needed to be a new liability notice. And it says there, as the development has commenced, a default liability notice will shortly be issued. The SIL liability notice from 2017 is attached at 107 through to 108, 9. The emails back from Mr. Bennett are at page 112, which says, Dear Lorraine, I refer to your letter to George Brathwaite, dated 19th of June, we acted on George's behalf in respect to planning, initial SIL forms, and are acting as contracting administrator. And then it says we confirm that the work started in August, 2nd of August 2019. At commencement, we corresponded with the council over issues in respect of parking and construction workers. So at that time, Mr. Bennett, on behalf of Meadow Properties and Mr. Brathwaite, was trying to stave off any concern or any sanctions and penalties that kick in after you commence without serving a commencement notice.
Mm-hmm.
And what he does is then refer to the fact that the council, as in other words, the local planning authority, had approved a phasing plan, and he suggests that perhaps that might form the basis of a means of an instalment process.
Yeah. Mm-hmm.
That phasing suggestion is rejected. If you turn back, my lord, to page 110.
Yeah.
And then it says right at the top, please can you confirm which permission was implemented? Now, my lord, that actually is a necessary question. As you'll find, the liability notice is served once the planning permission is granted. The first permits date is that of the planning permission, and therefore there is no need to wait to see which permission was granted. It would make no sense.
Mm-hmm.
What the liability notice records is, if you implement and commence this development, this is the liability you will be asked to pay. Then they reject the notion of phasing in the second paragraph, and they also draw attention to the fact that no commencement notice was served, and it sets out what it should contain.
Mm-hmm.
Now, my lord, again, the commencement notice can only come following a liability notice. It has to refer to the liability notice. And I can take you to the regulations, but it is a question of fact, and also that was highlighted in the subsequent appeal under 117.
Right.
What we do see at the bottom of that letter is a suggestion that instead of phasing, that they propose an instalment plan. Now, an instalment plan would have been available.
That's at the foot of the page, is it?
Yes, my lord. Sorry, it's fourth paragraph down. In terms of an instalment plan.
Oh yes.
It says, as the development is deemed commenced, it is due in full. So that is one of the issues that arises here. If you start without a commencement notice,
yeah,
you are at that point expected to pay all your SIL in one fell swoop.
Mm-hmm.
And therefore subject to statutory late payment interest. Now, my lord, that is significant because that is mandatory. Once commencement has started without any payment, statutory late payment interest is payable. It's still regulation 87, I believe.
Right.
It does not qualify for instalment payments. So would have done if there had been a liability notice prior to commencement.
Yeah.
However, it says we can agree a bespoke instalment plan and a deferral. Nowhere within this, my lord, is there anything that says we recognise that the liability notice is 16 months late. There is nothing in there to highlight to the appellant at the time that what he might be agreeing to is what Mrs. Townsend suggests was a waiver. So, my lord.
So no suggestion of waiver.
Well,
hold on. There hasn't been a new and late liability notice. They're still working on the assumption that the relevant one is the 2017 one, which I think was in time. It's just that it's the wrong notice because of the change in floor plan. Isn't that what this is about?
Well, my lord, what we know is that they knew they had to serve a fresh liability notice. So this is ahead of serving a fresh liability notice.
Right. Do we get that from the letter, actually, that they knew they had to serve a fresh liability notice?
Well, what the instalment plan would be shown on is the demand notice that comes, but it is subsequent to a new liability notice, because the 2017 notice does not apply to the development that has been commenced, and that is the point.
Right.
But is the local authority acknowledging that truth at this point in time?
Well, what they said before was that which is the last paragraph on page 106.
Yes, they say.
They refer to a default liability notice needing to be.
What does that mean? Does that mean a new liability?
A new one, yes.
I see. All right.
They did that on the 19th of.
So that was the letter of the 19th that said.
And it was within 10 days or so of that they did in fact serve the notice.
Yes, my lord. So on the 30th of June.
Are we going to that now?
Yes,
then?
that is on the next page, page 114.
Yeah.
There is the liability notice.
Yeah.
Dated the 30th of June, and it refers to a single sum of £871,000, £814.39. Various points are raised within the liability notice, including firstly how it's calculated, but also that the fact that new liability notices may be issued. That's on page 116. When any changes to the calculation or amount or anything that may affect the actual amount, and also it says it's up to them to notify if there's any change in the liable party. Notes the fact that if a valid commencement notice hasn't been submitted before development commences, SIL will fall due. Now, obviously, commencement had already begun, but that, my lord, emphasises the fact that if you commence prior to receipt of this, even if it's not your fault, this being the liability notice, that amount still becomes due at that point.
Yeah. This is in standard form, is it? This
yes,
notice? Except, of course, for the amounts, but the format of it is standard. Yes.
And also it refers to consequences of non-payment. So the penalties are there highlighted.
Yeah.
Now, could you have challenged this at that time?
No, my lord.
Why not?
The sum itself was not an issue.
Yeah, but the fact that it was very late.
Well,
why couldn't you if that's a good ground of complaint, vitiating its lawfulness?
Yes, my lord.
Why couldn't you have challenged it on that ground in July?
Well, my lord, we accept that we didn't twig, my lord, that would have been possible, because the SIL regime doesn't have a series of review and appeal processes that deal with a late liability notice.
Fine, but it's general public law that if you don't have a bespoke appeal mechanism, by default you can apply for judicial review. That's the whole point about judicial review. It's a remedy of last resort, but it is there.
My lord, we accept that the clients did not know that they could have challenged this on the basis that it was late, because nowhere was it being highlighted to it that this was a potential consequence. They hadn't understood that this was a late liability notice. It certainly wasn't highlighted by the council. So what they didn't do was go back and say this is a bit late. It didn't even cross their minds.
Forgive me.
Yes.
And I know you're going to come back to this.
Yes, madam.
So please don't take it out of turn by way of submission.
Yes.
But there may be two issues that in due course we shall need to address. One is, when did the grounds first arise? A second and distinct point is there good reason to extend time?
Yes.
And often there can be a good reason to extend time, depending on the circumstances,
Yes.
but one of them can be that the person concerned didn't know and perhaps could not reasonably have been expected to know that they could challenge at that time.
Yes. Yes.
But the extension of time point is,
Yes.
as I understand it, a different point from the first point, which is when did the grounds for challenge first arise? And usually that's taken to be when the relevant decision was issued.
Yeah, yes, my lord. And I know that this is a principal point against us because that the clients did not pick up that this was a late notice. We know that, but there are good reasons why they did not. What we say is that for various reasons this court can deal with this as invalid. This also including the 2020 demand notice, which is on the next page at 120, because that is parasitic on the liability notice.
Yes.
But that demand notice explains on page 122 how the instalment plan is to work.
There are two flaws, if I can call them that, alleged about the notice we're looking at. One is that it was far too late, so it wasn't served as soon as practicable, or whatever the formulation is. And the other is that it was served on the wrong legal person.
Yes, my lord.
At the moment, I mean, I'm struggling to see why it wasn't apparent to the claimant at that stage that these flaws were present in the notice and its service. That may just be another way of putting the question that my lord has already put to you.
Yes, my lord.
But at the moment I'm struggling to see why that was not quite apparent to the claimant at that stage.
My lord, we have been quite honest with this, is that Mr. Bennett and Mr. Brathwaite had never had to pay SIL before. All the developments they dealt with were subject to relief. They did not know that if you received a SIL liability notice well after time, that was a basis to challenge. And indeed, in terms of who the relevant person was and who was served the notice, my lord, those are technical points, but we say that the gravamen of this is that this was so late. But again, we accept that we did not actually recognise what that meant. Subsequently, however, the appellants did not pay. As a consequence of that, my lord, issues were raised again by the council saying you need to pay up in effect.
Yeah.
On the 29th of December 2020, a further demand notice. So the SIL notice stayed the same, obviously. The demand notice changed, and that's at page 127.
Yeah. But what I'm struggling with at the moment, and perhaps you can help us, is that you've shown us the correspondence that was the immediate prelude to the service of this notice, which was very much focusing, you say in some respects inaccurately, or may have been inaccurately focused on the payment of SIL. So the question might be asked, why then was it any surprise to the claimant to receive a notice requiring the payment of SIL? against that background? I mean, you say that he did not, or they did not recognise what that meant.
Well, the lateness, my lord.
Yeah, but if it was late, why was it that the lateness didn't make itself apparent?
Because, my lord, they didn't know.
You're saying they didn't have the benefit of legal advice at that stage.
I'm afraid they didn't know, my lord.
I mean,
I know that's never a great excuse, my lord, but that is the
part of the context is, would you agree, is that Mr. Brathwaite had for some time been expecting to pay this levy in about the same amount as the demand notice, and had in fact assumed liability under the 2017 notice, which,
yes,
even if it was the first time he'd ever come across them, appears to indicate some familiarity with the regime.
Well, I think he was told to.
Well, yes.
but my lord, this is what Mrs. Townsend argues is in effect it comes down to the Section 31 of Senior Courts Act point, which is that they should have known, they were familiar, that the sort of sum that is being asked for, even at a late stage, is the sum that actually it's slightly lesser than the 2017 sum. But my lord, what is missing from that understanding is that as a consequence of this coming after the commencement and all that implies about when the SIL is due, in other words, now, it is also that there is interest to follow. So there are penalties which follow, and also there is the ability to, on the council's part, to add surcharges. So there are sanctions and penalties that follow as a consequence of this late notice, which are not the fault of the appellant. And that is where we say that the prejudice arises.
Sorry, can we just distinguish?
Yes, ma'am.
Because it may be important to distinguish between interest and surcharge.
Yes, ma'am.
Is it right that the surcharge was only chargeable because there had been a default in the first payment?
There are a number of bases upon which to issue surcharges.
Yeah, but it's not the mere fact of issuing the late liability notice that gives rise to the surcharge.
Interest is what's
right. That's why I suggested that there may be an important distinction between
Yes.
interest and surcharge. Now, can you just help me with this?
Yes.
From what date did the interest payable become chargeable?
Well, it's from the date of commencement, and you can see that, my lord, if you look at the demand notice, page 132. So this is the subsequent demand notice when no payment was made. What that says clearly is that late payment interest runs from the 3rd of August 2019.
Yeah. And do you accept that? That's right. That's what they said.
That is mandatory. That is they. Whilst the council in effect chose not to charge it on the original demand notice, but for no, it wasn't explained why they didn't do that. They could also have issued surcharges because of a commencement, but that's a matter of discretion.
Yeah.
What is the rate of interest? Is it?
It's 2.5% above bank rate on an annual basis.
So it's a commercial rather than a penal rate.
I would suggest that's probably right, my lord. 2.5. That's the figure that's identified within the regulations themselves. So it's 2.5 above.
Yes. Well, that bears on whether it's proper to describe interest as a penalty, because if it's a commercial rate, it can simply be seen as, from the council's point of view, being kept out of money they ought to have had, or from the developer's point of view, having the benefit of not paying when you ought to have done.
Well, my lord, but we submit that it is a form of penalty in these circumstances, because it starts from the commencement, and we didn't even receive the notice until 2020. So there's a whole period that we are in effect being penalised for not paying when we didn't even have a liability notice.
But from the, as has been pointed out, but from an early stage, going back some years actually, Mr. Brathwaite and his company were well aware that there was a SIL liability here, a very substantial sum of money, whatever the exact sum was, then subsequently whatever the interest level was, and that is the prelude, the longer term prelude to the service of the late demand notice in June 2020. It doesn't come as a bolt from the blue by any means. Is that a fair analysis?
Well, my lord, with respect, the question whether whether Mr. Brathwaite knew that there would be a SIL liability is not actually the issue. It's because there are consequences that flow if you don't receive a liability notice until well after you've commenced your development, and when that is nothing to do with your own fault, as it were.
But the answer to the question, why didn't he challenge, or why didn't they challenge the notice served in June 2020, is that they didn't recognise what it meant, and they didn't have the benefit of legal advice, is what you've said to us.
Well, my lord, yes, but when they did receive the demand notice that had the surcharges and the interest attached,
yes,
it was at that point that they thought, especially as there is a specific appeal process that deals with surcharges, that they took legal advice.
So when did they start? When did they first take legal advice?
So, my lord, I haven't got the specific date in mind, but the appeal, if you can turn to the statement that the appellant put in at page 134, the appeal needs to be submitted fairly shortly, within 28 days of receipt of the demand notice. This statement was dated the 22nd of January 2021.
Sorry, page 148.
My lord.
148, sorry.
That's the end of the appellant's statement to surcharge.
Right, so at that stage...
so following, so that 29th of December 2020, they received the demand notice, and by the end of January, they had submitted their appeal in time.
All right, so that certainly as of the 22nd of January 21, we know that they had the benefit of legal advice.
Yes, my lord. And what they did as part of their Regulation 117 appeal, and my lord, it probably would be sensible to have the regulations open.
Yeah. So you want us to look at which regulation?
It's Regulation 117 and
117.
my lord, actually in passing, page 66 has Regulation 87, which deals with the late payment interest, and we wanted to be involved with that.
Okay.
And then 117 is at right at the back, page 78 of the authorities bundle.
Yeah. Thank you.
So, my lord, it is an appeal, and paragraph 1 of Regulation 117 clearly states a person who is aggrieved at a decision of a collecting authority to impose a surcharge may appeal on any of the following grounds. A, which also was one of the grounds that was relied upon, that the claimed breach which led to the imposition of the charge did not occur. And secondly, and perhaps more significantly for this case, that the collecting authority did not serve a liability notice in respect of the chargeable development to which the surcharge relates.
They did.
Well, my lord, this is where, I'm about to say it gets interesting. but this is where the issue arises, because the inspector, and there are a number of other decisions not before you, but the inspector who is appointed to deal with these appeals looks at B and says, well, was it properly served? Was it validly served?
Is that within his jurisdiction?
Well, my lord, we say yes. It was in fact the same decision that the inspector drew in the earlier case of Trent. That both failure in terms of the service requirements, so failure to serve on the relevant person, but also failure to serve an issue in time. And the decision letter, my lord, is at, follows on from here, is at page 158.
Yes. Yes, I've read that. You told us a moment ago that Trent, obviously we'll look at Trent
Yes.
if you want us to. No, please don't take it out of
That's
order.
right.
All I wanted to ask you at this
Yes.
stage was, has this issue of principle been considered at an appellate level previously?
No, my lord. What has been considered was we say a very similar set of circumstances where a late liability notice came. The difference being that the surcharge was charged immediately under the demand notice. So Miss Trent used her right to rely on 117, but also did rely upon the fact that, that there was a late notice.
I'm not suggesting that Trent is wrongly decided. I don't know. I haven't considered it sufficiently, and obviously we haven't heard submissions about it yet. But at first blush, to me at least, it does not seem obvious that when somebody appeals against a surcharge, that the appointed person has jurisdiction to go back and consider the validity of the underlying liability notice.
My lord,
That may be right in law, but it's not obvious to me, at least.
my lord, as I understand it, the way that it has been interpreted by inspectors, and it may be that this court disagrees, but it has been applied by this inspector and an inspector before him. I think it even might have been the same inspector, but which is that if you're looking at whether service was affected, it's not just whether it in effect landed on your doormat, it is also whether it was served to the right person, but also whether it was served validly. And that relies upon a lot of the authorities about the form and reliability, as it were, of notices that have come before.
And does that include the ground that it was served very late? In other words, not as soon as practicable. I can see, I'm not saying I agree with it, but I can certainly see an argument that it can be said that the liability notice has not been served at all.
Yes.
If it's been served on the wrong person, I can see an argument that it just hasn't been served. I can see that. What I'm less sure about at this stage is that you can say it hasn't been served because it was served 18 months after it should have been.
Well, my understanding, and on my, maybe it is my own interpretation, but is that what the inspector did was look to the regulations and to say, well, has this been validly served? And is it, my lord, a liability notice?
Yes.
So not only look at service, whether it physically was posted out of the door and landed with the right person, but also whether it has been issued in effect on time and is therefore a valid liability notice, because this inspector did go that far. And we say that he was entitled to, but also the council has never suggested that he was not. What they do say is that that in effect you can ignore his comments about the validity of the liability notice on that basis because he can't quash it.
Yes.
And that's where we differ, my lord, because we say the appellants took a route available to them to challenge the notice and to challenge the demand notice, and were the recipients of conclusions about those and their lawfulness by an inspector.
But what the inspector could not do, and this is, I think, common ground, is quash the liability notice.
Yes, my
He
lord.
didn't have jurisdiction to do that.
He didn't.
So your argument must depend, mustn't it, therefore, on the liability notice not being a liability notice at all.
Yes, my lord.
Is that right or not? Don't accept it too readily. If I'm wrong about it, you must tell me. But your argument, for your argument to work, I think, you must be contending to us that the liability notice that was in fact served on the 30th of June 2020 was not a liability notice at all.
It was not a valid liability notice, yes, in that it is out with.
But who is to say it is? Who is to conclude or determine whether it is valid? Not the inspector you've accepted.
Well, the inspector can clearly look to whether those regulations were accorded with.
Yes, but that's only within the jurisdiction that he has on a surcharge appeal, not within any wider jurisdiction.
My lord, he makes those findings, and we can certainly look at the wording that
Yes.
the inspector uses.
Yeah, and these questions are predicated on the fact that he did in fact do that. We're, I think, now shining a light on whether his conclusions really reflect his jurisdiction or not.
Well, my lord, paragraph 4 of the appeal decision.
Should we look at it together?
Is important.
Yeah, let's do that.
That's page 159 of the supplementary bundle.
Yeah. Thank you.
Paragraph 1, I'll do this very quickly, but paragraph 1, that the inspector introduces that the main basis, which is that failed to serve correctly serve a liability notice by not serving one directly on him in accordance with 65.3, and failed to serve as soon as practicable after the day on which planning permission first permits in accordance with 65.1. So he accepts those bases for the appeal.
But his conclusion at paragraph 6 is that the alleged breach that led to the surcharge did not occur
Yes.
because of the late service, and therefore he is exercising, or purporting to exercise, the jurisdiction under regulation 117.1a, not b.
Well, my lord, what he says in view of the above, not correctly served, my lord, that is 1b.
Well, and consequently,
Yes.
and
Yes.
well, it seems to me the reading is clear and is as I put to you, but
Well, my lord, yes,
if you
but it's
disagree,
both.
then so be it.
It's both, my lord. Forgive me. It's both 1a that the surcharge did not occur, but based on b because it was not served. And my lord, I know that Mrs. Townsend takes paragraph 6 to say it was only, and if it was b, then it was only service, not to deal with the issuing of it late. But given, we say, that the way that the inspector dealt with it, and he was a planning inspector, he is a planning inspector, we say must have included his consideration at paragraph 4, where he says, concerning the timing of the issue of the liability notice, as mentioned, Regulation 5.1 explains that the Council must issue as soon as practicable after the day on which first permits. In this case, a liability notice not submitted for some 16 months after permission was granted. The Council explained that the reason for this delay was due to trying to establish when work had commenced and on which planning permission, as they had not received a commencement notice. So, my lord, that was the Council's position even then, They did not say, oh, we accept that it was late. What they say is we acted reasonably, but you should have served a commencement notice.
Yes, well, there are two questions here. One is whether there ought to have been a challenge by way of a claim for judicial review to the June 2020 liability notice. That's one question. And the second question is, which may or may not arise, whether or not there would have been a proper defence to such a claim. But the reality here is that there wasn't a claim. That's a fact. And we're now looking at the degree to which the inspector's jurisdiction extended anywhere near the question that would have been raised had there been a claim.
Well, my lord, yes, but the bottom line is that the appellants did avail themselves of some form of relief as a consequence. It may not have been the perfect one, but certainly what they had was a ruling from, or a finding from an inspector that accepted that this notice was late and outside of 65(1), that what's more, the council's suggestion that this was because there'd been no commencement notice was not accepted, because if you look at paragraph 4, as the liability notice is required to be served before the recipient is required to submit a commencement notice, the liability notice acts as a trigger for this to happen. So he doesn't accept the council's arguments, and indeed he goes on to say it is also not possible to submit a valid commencement notice before service of a liability notice, as the commencement notice requires the notice to be identified. Council argued the appellant would have been aware of the need to submit a commencement notice from its previous assumption of liability. Again, the appellant having knowledge by other means does not act as a substitute for the required notice. So, my lord, we say that the inspector was very clear about his finding.
And the first sentence of paragraph 5 is crystal clear.
Yes.
He definitely decides that point in your favour.
What's more, he says the council withdrew its instalment plan and imposed the late payment surcharge as a result of the appellant's failure to submit a commencement notice. He doesn't say because he simply failed to pay. And my lord, if you turn over, the inspector, actually, sorry, paragraph 7 is at the bottom, and then you turn over. The inspector looks at this issue of interest, which was charged. At that time, it was some £35,000. And at that point, he refers to Trent and the ruling that Ms. Justice Lang made about it being contrary to Article 1, Protocol 1. This is despite, again, the interest being mandatory, but he says it's reasonable to conclude from this that any pursuit of a claim for outstanding interest is likely to be unsuccessful due to the impact of Article 1, Protocol 1. So, my lord, the inspector goes quite far. He not only says the liability notice is not valid, it's not a valid liability notice because it was served, it wasn't served as soon as practicable, but also that the interest should not be charged. So that gave, perhaps, in all the circumstances, the appellants quite a lot of hope. Yeah. Because he comes down and says, this is not a valid notice, this is not to be relied upon, and what's more, you can't ask for interest in these circumstances. Yeah. Now, my lord, the council did not challenge that.
No, but what this shows, actually, one could say, couldn't one, is that insofar as the inspector adopted the argument put forward by the present appellant, that argument was formulated and advanced in September 2021 or so. When was the
January 2021 was the appeal. The decision didn't come until September.
The decision itself was long delayed for some reason. But anyway, it was being advanced. That argument was being formulated and advanced in early 2021. That was some 6 months after the notice had been served.
Yes.
But even, I mean, Ms Townsend, I apprehend, would say, even when you get the decision of September 2021, you don't launch a challenge. You formulated the argument in January, didn't launch a challenge. You get the decision favourable to the argument in September, didn't launch a challenge.
Well, we did.
All against the background that the inspector doesn't have jurisdiction to quash the notice.
Well, we did launch a challenge.
Well, not yes, but you didn't launch a challenge directly to the 2020 notice.
No,
You
my
launched it very deliberately to the 2021 notice, which came after the appeal decision by some 4 days.
Yes, my lord, but the consequence of waiting for this SIL Regulation 117 appeal was those sorts of rulings that the appellant sought to and was entitled to rely upon. And this comes through which is the same approach that Mr. Justice Lang accepted in Trent, where it was said, well, because the inspector can't quash a late liability notice, that the inspector's decision has no impact, has no force. And what Mrs. Justice Lang said was, no. In these circumstances, the council should have taken on board the inspector's comments and not actually served a new notice. So, which explains why I did that fairly lengthy chronology, which shows that the comparison between Trent and the facts here. And we say that whilst there was no judicial review of that 2020 notice, we are entitled to rely upon the rulings of this inspector to confirm that it was invalid. And my lord, perhaps it might be interesting to compare that with this court's judgment in Arnold White.
Yeah.
Because whilst that was also looking at why earlier action wasn't taken, that's at Authorities Bundle 148.
Yes.
It wasn't that long ago, but the perhaps I can summarise the facts from that, which was that it was a breach of a restocking condition under Section 24 of the Forestry Act 1967. I'm looking at paragraph 1 of the judgment. And in simple terms, whilst there'd been they wanted to challenge the basis for that restocking condition as a consequence of a planning permission, the appellants in that case chose not to challenge under Section 25, which they could have done. And my lord, that's noted at paragraph 30.
Yeah.
And then paragraph 50. But what I need to add, of course, was that and I don't mean this in a bad way, but a device was used in order to get the matter before the court by saying you need to back off from the Section 24 condition and because of the impact it has on the planning permission. And it was that decision to uphold the Section 24 of the commissions that was challenged, not the Section 24 notice. Now here, paragraph 50, what you say, my lord, was that in suing in favour of Arnold White Estates, that on the facts its complaint fell outside the clearly defined grounds of a statutory appeal under Section 25 against the Section 24 notice, and that in such circumstances the notice might in principle have been susceptible of challenge. Well, my lord, what you say is that they didn't do that. They didn't even take up that imperfect challenge.
Yeah,
Whereas,
well, doesn't that parallel the situation here? Of course, different statutory scheme, and we must caution ourselves to remember that. But in Arnold White, there was a period of 6 months, as I think all parties accepted, of silence. Nothing happened. but the challenge came very late eventually, and it was ostensibly on the basis that the decision not to withdraw was a continuous state of affairs,
Yes.
which this court rejected. But there is a parallel, isn't there, in the sense that there was a statutory appeal route which wasn't taken advantage of, and then a very late claim brought for judicial review.
Well,
In this case, in the present case, there has been even now, no claim for judicial review clearly and firmly aimed at the 2020 liability notice, although it's fair to say that the claim does invite the court to grant a declaration as to the effect of that notice. But it's not actually the decision against which the claim is directed on the face of the claim form.
yes, my lord.
So even now there isn't actually a direct challenge to that notice.
The reason being that notice doesn't exist anymore, which is what brings in the cease to effect.
So it doesn't exist anymore. When did it cease to exist?
At the point when the 2021 notices were issued. So there is no, this is Still Reg 65.8, and I understand that Mrs. Townsend argues that, or suggests that we're saying that it has a retrospective effect. That is not our argument. Our argument is we chose the right notice to challenge, the new liability notice 2021.
Yeah.
And that the 2020 notice has no life anymore. But all we can do, again, like we thought, like Trent, was to say, well, the inspectors told us that 2020 notice is invalid. It is invalid.
Yeah.
And therefore the 2021 liability notice can't cure it.
So if that's right, then if the 2021 notice hadn't been served, the 2020 notice would still exist.
Well,
because you just said that what caused it to cease to exist was the 2021 notice. So it must follow as a direct corollary of that if the 2021 notice hadn't been served, the 2020 notice would still exist.
Well, my lord, but if the 2021 notice were to go, there would still be an invalid notice.
Well, it goes further, doesn't it? If we were actually to quash the 2021 notice on the basis of the response you gave just now, the 2020 notice would still exist. So if you got the relief that you're seeking in the proceedings, the 2020 notice would still exist.
But my lord, yes, if it revives, but my lord, it is still invalid.
But it wouldn't have to revive because it wouldn't have ceased to exist by virtue of the fact that the 2021 notice has been struck down, which is what you're seeking by these proceedings.
My lord, I described it in a slightly euphemistic way in my response. If I can find it, the question here is that the 2021 September liability notice is a fresh notice. It is reliant upon there being a valid notice before it. And that is also the council's case. And the council says, well, because it wasn't properly challenged, it must be treated as valid, despite what the inspector said. And we say, well, you acknowledge that it wasn't valid, or it was served in breach of the regulations, and therefore, again, like Brathwaite, it's a continuing state of unlawfulness. But what you cannot do by serving a new liability notice is scrub its face clean, scrub its forehead clean of that invalidity. That is not the purpose of this regulation system. And the point about taking up the SIL Regulation 117 appeal is that it was an avenue that was open to the appellants, and through that we had a ruling upon the liability of the notice. Now, I understand the criticisms that that at some point that there could have been a judicial review at the time. But what would have been said, my lord, is, well, hang on, you're pursuing a surcharge appeal at the moment. You can't, why don't you wait for that ruling to come out? Because what that is looking at is specifically the same issue. So, my lord, with respect, I don't think the appellants can be criticised for not taking up a judicial review challenge during the course of the Civil Regulation 117 appeal. The consequence, my lord, of the council, in effect, accepting in its pre-action protocol that the 2020 liability notice was indeed issued in breach of the regulations, but because beforehand they had not said that, it was significant, we say, because that must mean that it is at least, I know we don't want to start going into avoidable, but it is at least on its face invalid, even if it had not been quashed. They are willing to accept that position as an invalid notice because they say, well, in effect, the inspector, you chose the wrong route. And we say that is an unattractive position for the council to take because it now accepts that notice was in breach of Civil Regulation 65(1).
Well, that may be the crucial distinction as a matter of law, is to accept that something is in breach of a legal requirement is one thing. To go on to say that it is therefore invalid doesn't necessarily follow, because as long ago as I think 1956, the House of Lords said that a decision doesn't carry the badge of invalidity on its forehead. It all depends on whether it has been set aside by a person, usually a court, having the jurisdiction to set it aside, at the suit of a person having standing to bring it within the relevant time period. If none of those things have occurred, the public law acknowledges that a decision may well be in breach of the law, in one sense, and yet is a perfectly valid decision, which has legal effects.
Well, my lord, of course I accept all of that, but we do say that there is significance in the inspector's conclusions, and for this court not to agree with the inspector, we say would be wrong. The nature of this liability notice, and I accept also that the way that the claim has been formulated is on the basis of the 2021 notice, because that is the one that exists. There can be only one. You can only have one liability notice, and therefore, which is why we disagreed with Mrs. Justice Lang when she said it still exists. It simply doesn't exist. So what we sought was the declaration that the 2020 notice was void ab initio, which again was.
Well, that's a different. Again, forgive me for interrupting you, but there you've then again leapt from a premise to conclusion, which doesn't necessarily follow. I can understand your argument that the effect of Rule 65(8) is that the 2020 notice ceased to have effect from the date when the 2021 notice came into effect.
Yes.
I can see that. It doesn't follow that the 2020 notice never had legal effect. And when you start using words like void ab initio, that implies that it never had legal effect.
Well, that is what Mrs. Justice Lang chose to do in Trent in very similar circumstances.
Right.
Where a notice had been served late. Initially, there had been a mistake with the computer and no liability notice had been served on time. a subsequent liability notice was issued, which was well after commencement, and Ms Trent went down the Regulation 117 route immediately. We couldn't do that immediately because we didn't have a surcharge. But when the inspector in Trent said this is in breach of the 65(1), the expectation that Mr Justice Lang had, or said that the appellant was the claimant in that case was entitled to have, was that was the end of it. And she used her discretion to say, well, that notice that came late is void ab initio.
Well, again, personally, it's a matter of taste to some extent. Personally, I don't like words like void, voidable, void ab initio, and so on, because it all depends. And it is certainly the case that normally, if a court of competent jurisdiction does exercise its discretion to quash a decision, normally the legal effect of that quashing order is that the decision is treated as if it had never existed. Even that isn't universally true, in fact. There are exceptions, but we don't need to go into those today. But the crucial point is that to date, no court has ever set aside the 2020 notice. And that the simple point I think Mrs Townsend makes is, therefore, in law, it does still exist, certainly did exist, up to the date when the 2021 notice took effect.
My lord, I don't say that there was a retrospective effect. What I do say, though, is that the notice was, I suppose, it was invalid on its face. But in order to try and avoid it.
But why do you need any of this? I thought your simple ground of challenge by way of judicial review is, first of all, it's to the 2021 notice.
Yes, ma'am.
And secondly, as I understand it, your ground for challenge is that was made many years after the relevant planning permission in February 2019.
Yes, ma'am.
Ergo, it's not as soon as practicable. Right? Is your argument any more complicated than that?
Well, my lord, no. But what is clearly has to be dealt with is the fact that prior to that there was an invalid liability notice, which gives no life to or no valid life to.
So why on your submission do we need to go into all of that? I can see that may be raised by way of defence, but why on your submission does any of that matter? If you say, quite simply, the 2020 notice doesn't exist any longer, that's the effect of 65(8).
Yes.
So when I issued these proceedings in December 2021, I couldn't have challenged that. There's no decision there.
Yes.
But even if that's wrong, what I have chosen to challenge is a decision issued in September 21. I'm within time to challenge that.
Yes.
My ground of challenge is that it was issued far too late. Now, either that's a good ground or it's a bad ground, but I thought you say very simply, I've got no delay problem, and I've got no other problems, just deal with this on its merits.
Well, my lord, yes. But the reason that we have to take into account the fact that there was an earlier notice was because what is argued back. Because what they say is, well, it doesn't matter that this is a new notice that comes X years after the first permits date, because it is reliant upon a previous notice that may have been late, but is valid because nobody challenged it.
Yes, I see.
And my lord, what we say therefore is that, and this is perhaps where I briefly go into my 4-point submissions, which I'll end with, my lord.
Well, I wonder.
Yes.
I'm sorry, I don't want to interrupt you.
No, please, my lord, please.
Wrongly, but just before you go back to that, we should recall, perhaps, by way at least of a tailpiece to your response to my lord, that the provisions of Regulation 60, 65.
My lord, they are.
No, not 65.
65 is the 51, my lord. Authorities bundle.
Yeah.
Is it 117?
It's the provision at any time that I was seeking.
It's 65.8, which is on
Yeah,
page
65.8,
59.
thank you. I was in the wrong place.
65.5 has the words at any
Yes.
time.
Yes.
65.5.
That's
Yes.
a revised liability notice.
Yes.
Yes.
Is that on as you understand it? Is that what the local authority is purporting to have done here? That they issued a revised liability notice?
Well, they say that they did, yes,
Yeah,
and we
yeah,
say...
yeah. So that's why you have to...
We say it's a new liability notice.
Yes, I see.
Yeah.
Yeah. And my lord is quite right, of course, to point out that paragraph 5 says may at any time.
Yes.
So the soon as practicable requirement doesn't bite, as I understand it, on a revised liability notice.
Well, my lord, it has to revise something. So it would have to, if the original liability notice is served out of time,
Yeah.
then we would say it can't be cured by issuing a revised liability notice.
Yeah.
The essence of what I'm saying is that the regulations clearly don't allow for an appeal system that says if you serve a liability notice late that you can go down an appeal route. But what they do say is that you do need to comply with the regulations, and that a revised liability notice, yes, it may be possible to issue it at any time. But my lord, what we know is that paragraph 6 clearly shows that a liability notice clearly must be served in accordance with all the other paragraphs, which can deal with who it's to go to, etc. And paragraph 7 clearly shows you can withdraw a liability notice.
Yes.
Subparagraph 8 is clearly the one that we have drawn attention to. So any earlier liability notice, when a liability notice is served, issued rather, seems to, and it has to relate to the same chargeable development, ceases to have effect. So
What would have been the effect then of withdrawing the 2021 notice?
there would be no liability notice, my lord.
Because?
Well, my lord,
That comes back, doesn't it?
It
We
ceases
are
to have
drawn
effect.
back because we have to look at the statutory scheme as a whole. The statutory scheme incorporates, as you've pointed out, a specific provision for withdrawal. To test, this is not, of course, the factual scenario we're dealing with, but to test your argument, perhaps, postulate that the 2021 notice is withdrawn. You are drawn back then, aren't you, to the argument that the 2020 notice not merely ceases to have effect, but actually is unnoticed.
Well, there is,
Non-notice.
yes, there is no.
Now, and you're drawn back to the quotes nullity unquotes argument, aren't you?
Yes, my lord. I mean,
Which you've been debating in your responses to my lord.
what we say in terms of my principal point about the importance of liability notices is that they clearly are fundamental, and what's more, as Mrs. Justice Lang put it in Trent, so we finally go to Trent.
Oh, right, yeah, you'd like us to look at Trent now.
Yes, it's page 233, my lord, of the bundle. Where
Paragraph.
paragraph 55,
Yeah.
my lord, on page 232, there's reference to the case of Shropshire, where Mr. Justice Opperton looked at Jonathan and made these rulings about the format of a commencement notice and how important it was that it complied, and in effect that if it didn't comply with the relevant regulations, that it was not a commencement notice at all, and that's subparagraph 37 that's quoted at page 55, paragraph 55. But the conclusion section is what I say is important, my lord. Paragraph 57 on top of page 233 says, in my judgment, the defendant was required to issue and serve statutory notices which complied with the requirements of the SIL regulations and to do so in the prescribed sequence. In consequence, the claimant was not under an obligation to pay the SIL as required by the 2020 demand notice, that's the one that came after the inspector's decision, until the defendant had issued and served a valid liability notice in accordance with Regulation 65. So that is what Mrs. Justice Lang concluded about the importance of liability notice, but also that if you don't have a valid liability notice, there is no obligation to pay. And that is a pretty fundamental point, my lord. I accept that she goes on to look at various circumstances which are relevant in the round. So, for example, at paragraph 60, she says, in considering the effect of any non-compliance with Regulation 65, it is necessary to consider the nature and purpose of the liability notice requirements in the context of the overall statutory scheme. So this is my point one, the purpose of the liability notice within the scheme. I'm not going to read all of that out, my lords, but what it clearly shows, and at paragraph 61, Mrs. Justice Lang goes through what is critically important about it. Subparagraph 9, for Roman 9, she also highlights the fact that it explains the consequences of non-payment, including liability to additional surcharges. So the liability notice and getting it right and serving it on time, or at least as soon as practicable after the first permit state, is important for a number of reasons given what it contains. But also, my lord, there are consequences if you do not serve as soon as practicable. My lord, that is not actually dealt with in Trent, but we say it must be relevant because, for example, you could serve a notice as soon as practicable even if development has commenced, and that risk is obviously on the developer. And whatever consequences, the consequences of starting without a commencement notice mean that time starts to run, your liability kicks in, as it were. In other circumstances, however, a developer shouldn't have to wait for a liability notice to be served, because it is not upon the developer to actually prod the council to serving it. I'll take you to, very briefly, to Regulation 31. Which is at Regulation 31, which is at page 46 of the bundle, the authority finding. And this is the assumption of liability. And it says in terms of a person who wishes to assume liability to pay SIL must submit an assumption of liability. So it is an option. The consequence of not serving an assumption of liability form, we turn over the page to Regulation 33. You have a situation where chargeable development, this is paragraph 1 of the regulation, chargeable development is commenced in reliance on planning permission and nobody has assumed liability. So that's what happens if nobody has. But also, returning to Regulation 65, which is at page 50, it's subparagraph 3, paragraph 3, says that the collecting authority must serve the liability notice on the relevant person, and B, if a person has assumed liability to pay still in respect of the further development, and then each person known to the authority to be an owner of the relevant land. So it is very clear that there is no duty upon the developer to, in effect, as I say, sorry, prod the council into issuing the notices. And the consequence, therefore, of a developer, on the one hand, not having to notify the council that it's assumed liability, and then having to wait, perhaps, for a liability notice in order to avail itself of any instalment or any advantage to the fact that it's dealing with still in effect before commencement, would if you happen to wait for that, you will be delaying your development entirely. And indeed, there are circumstances where liability notices come after the development is actually finished. So there is an importance to the timing provision because of the consequences of commencement.
Can I ask you in that context, if you don't succeed in quashing the 2021 notice, will the consequence be that you have to pay interest going back to August 2019?
That would be a matter for the council. It is mandatory.
I thought you said it was mandatory.
It is mandatory, but at the moment, the 2021 notice doesn't, because it took that much of the inspector's decision into account.
Oh, I see.
But it is mandatory, and therefore, if they chose to issue another notice or a demand notice that had it in, there is nothing that we could challenge that on.
I see. And I had another question, if I may, which is, if you don't pay for whatever reason, and they want to recover the money, how do they go about doing that? Do they sue in the county court? Or?
There are various enforcement provisions, and they can take, or they can. If at the moment, I think we're still in the process of developing. I don't think we've finished, so they could issue stop notices.
I see. Really. Yeah, but if they actually want the money, right, this is what I'm really getting at.
Yes,
presumably there is some appropriate forum, is there, where they can go and say this money is owed according to law, and therefore we want it, please.
There are enforcement provisions, yes.
And is that, it may not matter, but is that in the county court, or it may not matter?
I have to say, my Lord,
don't worry.
I'm very happy to find out precisely where it happens.
That may not matter, but the real question I'm going to ask you,
yes,
which may matter, is if they did sue you for the money,
yes, my Lord,
could you then, as per Wandsworth, London Borough Council and Winder, raise by way of defence that the money is not in truth owed because it's claimed under a decision which is invalid?
Well, my Lord, it might be worth a go, but I don't.
Well, what's your submission? Could you do that?
If the notice was upheld in this court, however, it would be very difficult.
Right.
I would suggest for that to be resisted, but because the parallel in my mind that I'm drawing is where you have an enforcement notice, where the enforcement notice has not been challenged, planning enforcement notice, and it's not been challenged, but if it's not complied with and then there's a criminal prosecution, then you are still, in effect, committed to raise validity. But off the top of my head, my Lord, I'm afraid I don't know whether
it may not matter, but it just, to my mind, what this illustrates is that concepts and words like validity are really very elusive, because something can have legal effect in one context, although it may not be treated as having legal effect in another context. And one example of that is it doesn't matter, it's not relevant at all on these facts, but in other contexts
Yes.
which concern unlawful detention, all the time people sue for false imprisonment. There's a Supreme Court decision called Lumba in 2012 where they said that when you bring an action for false imprisonment, you're entitled to say, in the context of a civil claim for damages, that your purported authority to detain me is of no legal effect. And you don't have to have challenged that by way of judicial review. You're not bound by the normal time limits for judicial review. Wandsworth and Winder holds that you can, in certain circumstances, raise invalidity by way of defence to a civil claim for a debt. So, and again, that's in circumstances where you had never challenged it by way of judicial review. So it all depends on the circumstances, it seems to me.
Yes,
but I think what the fundamental point that's made against you is that you are challenging by way of judicial review, but you're only challenging the 21 notice. And the fundamental point made against you is that that's wrong in substance, because in substance, the grounds first arose in June 2020, because the substance of your complaint is really that it's the June 2020 notice which is invalid, and it said you're far too late to challenge that by way of judicial review.
My Lord, yes, I know, I understand that. The difference, or we say that the what is critical about 65.8 is that it brings an end to the life of that invalid notice.
Yes.
And therefore, this new 2021 notice can't clean that.
Yes, I see.
Can't cure that 2020 notice.
Yes.
And we say that cannot be the purpose of those provisions. I'm not going to go to them, but there was a certain amount of explanatory documents that we submitted that shows that at one point it was said supersedes,
Yes.
and now it says cease
No,
to have effect.
I've read that.
I don't propose to take time through that.
No, it's very
but
helpful.
it was interesting to see that is what it's supposed, in effect, to be.
Yes.
And the cease to have effect is what we have now.
Yes, thank you.
You make the submission that the revised notice, even if it can be issued at any time, does not cure a previous late notice, but would it be right to say that where the substance of the complaint is that the previous notice was late, the time for challenge for JR purposes still runs from the previous notice?
Well, but the revised notice also leads to the ceasing to have effect. There's not the revised notice is dependent upon it being also the only one. So a revised notice is clearly reliant upon the previous existing liability notice. The new notice that we say that the 2021 notice is in effect even further removed.
Or to put it in perhaps more homely terms, the revised notice is built on the previous notice, but in order to challenge the revised notice, you nevertheless have to kick away the previous one.
Yes. Yes, my lord.
And that's what your real ground of challenge is.
Well, except that we say it's not a revised notice, we say it's a fresh notice, and therefore it is
Yes.
in effect that the 2021 notice is a fresh notice, because the revised, the original 2020 notice is not.
Well, the statutory scheme doesn't have an express provision that deals with my lord's question, but as it were, the normal law applies, one might say. And the normal law is that if you want to challenge something, you have to get on with it, basically. So that principle, that normal principle, sits perfectly well with the concept in Regulation 65(5), collecting authority may at any time issue a revised liability notice. There hasn't been a challenge to the original notice, then there hasn't, and that subsists. And that is the foundation, the continuing foundation for a revised liability notice. It's not anomalous or some form of mischief by omission. It's simply the way that the law works.
Well, my lord, the argument that we try to have is that the Civil Regulation 65 is aimed at making sure that notices get out on time, and therefore, if you offend that, if there is a breach of that as soon as practicable, and I accept it's a qualitative.
65(1).
Yeah, 65(1).
Yeah.
That is perhaps a fundamental breach of those regulations, and if you're and combined with the fact that the appellant did challenge it, albeit not through a judicial review, but through the Civil Regulation 117 appeal process, by saying this liability notice cannot form the basis of a surcharge, that ruling, in effect, even if it does not lead to the quashing of the notice, certainly means that it is not, I don't want to use the word valid again because I know, but it is certainly, and is accepted not to have been served in accordance with those regulations, and therefore is what we say is a continuing position of unlawfulness. Now, if a new notice is to come along in circumstances where it is accepted that the liability notice is out of time or reserved not as soon as practicable, that another new notice can't cure that.
You obviously don't like the expression revised notice as applied to the 2021 notice, and I understand that, and
yes.
so you call it a fresh notice. But can I just understand
yes,
the distinction you're drawing there? Are you saying that it must be seen as a fresh notice because the 2020 notice was served late and is therefore
yes.
invalid?
Yes.
Using that word in quotes.
Yes.
I mean, that's why you say it's fresh.
Yes.
Yes.
Yes. In other words, we did challenge the right notice.
Now I understand your distinction between fresh and revised now. Thank you.
My lord, I think I've dealt with point one and the importance and purpose behind Civil Regulation 65 and what it does. I have my second point obviously was to deal with Civil Regulation 117. I think I have exhausted my submissions on that. I think you understand what I'm saying, and we say in particular that that the council was forced to recognise that those conclusions were correct. Yeah. My third point was 65.8. I think again I have been through all that, so I'm not going to repeat the submissions on those.
Right.
But lastly, perhaps to deal with the prejudice point and whether or not, in the circumstances, if it is right that to allow an extension of time to challenge the 2020 notice.
Yes. Perhaps just while we're drawing breath at this
yes,
stage, I'll just invite my colleagues to ask any questions they still have on your issues 1 to 3.
Yes.
Maybe that we've exhausted our questions for the moment. So we're now, thank you, we're now turning to prejudice.
Prejudice.
Prejudice stroke section 31D.
Yes.
Stroke waiver stroke section.
Stroke waiver, yes. I'm sorry to wrap it all up, but it does actually, it is based upon the same surrounding facts, which are and indeed that I spoke about in introducing the facts. The first is that, in effect, there is no prejudice because the appellants knew about SIL and knew about the sort of levels of SIL that were to be paid, and what's more, that in receiving a liability notice, late or otherwise, that makes no difference to the amount. Well, we say clearly it does because of the potential penalty. We say it is a penalty, my lord, of the mandatory interest. And I'm afraid I did a very rough calculation, but if that interest was to be placed upon the amount today, it would be some almost £60,000. So we say that is an indication of the sorts of prejudice that at least that the appellant is looking at, and also it is still open to the council to issue surcharges. So we say there certainly is prejudice, and indeed, as I understand it, it's a basic principle of tax law that where there are, in terms of the principle of I think it's called the principle of certainty. Forgive me, I am not the tax specialist here, but that where there is uncertainty about a penalty and whether that should be imposed, the courts interpret that position in favour of the payee, so that there should not be prejudice arising to the payee if it's not clear whether or not they're going to be penalised, in fact, and this is the situation the appellants are here. Currently, there is no interest being charged. Currently, there are no surcharge demands being made, but it's certainly clear that they could be, and we say that there is nothing within the appellant's power to stop that. We also don't accept that the appellants waived any breach that the council caused as a consequence of the late liability notice. Firstly, as I explained, when at the time that the 2020 liability notice was being served, that certainly wasn't being said, here have have the instalment plan because we've made a mistake and it's too late. There was nothing about the liability notice in 2021 that alerted the appellant to the fact that there may have been a mistake made by the council, or that it recognised that it did. And that was also what was reflected in the 117 appeal. Sorry,
you maybe do mean the 2021? Sorry. You said 2021, but I just...
Oh, sorry, I mean the 2020.
Yes, I thought you did.
Yes, there is no waiver of the 2021. It's the...
So nothing relating to that 2020 notice that indicated that they had made any mistake?
That they'd made any waiver. But the council didn't suggest until the pre-application process when we challenged this notice, the 2021 notice, that it accepted that there had been a breach.
Yeah, that's what I thought you meant.
Sorry, yes.
Yeah.
And also, of course, the appellant didn't pay following the liability notice in 2021 and demand notice in 2020 and 2020. The June 2020 liability notice and demand notice, there was no payment following that.
But it did pay at some point.
Yes, my lord, there was a payment because that came after the surcharge demand notice in late 2020, because what they were being threatened with is stop notices. So in order to protect themselves, they paid one of the instalments. And there is a further notice, which I'm not taking you to because it's not relevant, but that records that payment, and that's also reflected on the 2021 notice.
Is that in the bundle?
Yes, it is, my lord.
Don't take us to it, but at some point, if we could just have a reference to the pages.
It is. It is page 137, my lord.
Of?
Tab of the supplementary bundle.
Thank you very much.
My lord, again, in terms of the application of section 2021 of the Senior Courts Act. That's at page 6, my lord, of the authorities bundle. Sorry, page 8 of the authorities bundle.
Would you like us to have it in front of us? As you
I think you probably
Yeah.
are very familiar with it. So.
Well, we are, but it's always helpful.
Yes, my lord. So, page 8, my lord.
Yeah, thank you.
And of course, my lord, forgive me, I didn't raise this at the beginning, but I have approached my arguments on the basis that this is a rolled up hearing, because clearly we are seeking permission to grant leave.
Yes.
Yeah, I think you're right to have approached it in that way, given the observations made by Lord Justice Lewison when he granted permission to appeal. He granted permission to appeal,
Yes, my lord.
but ordered that the matter be retained in this court. The practical effect of his order is that we should be dealing with everything in one fell swoop, I think.
I have approached it, I'm afraid, on that
without-
basis, but I didn't.
Yeah.
Forgive me for not raising it.
Yeah, I mean,
at
that
stage,
doesn't
but-
in any way preclude our decision making ultimately on
Thank you.
the way in which
Well,
we decide it.
But obviously that means I have to look at 3C as well as 3D.
Yeah, no, you do, yeah.
So that's why I raise it now.
Yeah, of course, yeah.
And that's at page 7 and page 8 of the authorities bundle. So 3C obviously says that the court may have its own motion when granting deciding whether to grant leave is to consider whether the outcome for the applicant would have been substantially different if the conduct complained of had not occurred. Now clearly the conduct complained of is the latent service of the 2021 notice, but I accept that given that we're seeking a declaration about the 2020 notice, that it has to be relevant. And the bottom line is we say that if the notices, or if any notice had been served as soon as practicable in accordance with 65(1), then firstly the appellants would have had benefit of an instalment plan which comes as a matter of right through the council's own policy. And my lord, if you wanted to look at that policy, that's right at the front of the supplementary bundle. It's the first document, page 5. But also that there would have been no threat of surcharge unless they'd failed to pay, but in particular that there would be no threat of, no compulsion to charge interest, because interest only gets applied, and I can take you perhaps more sensibly to Regulation 87 where it's set out. My lord, that's at page 66 and 67.
And the interest which is payable is simple, not compound interest, isn't it?
I will defer to you.
Well, isn't that what
Yes.
paragraph 3 means?
Yes, my lord.
And if not, what does it mean?
Yes, yes, exactly. Sorry, yes. It is, yes, my lord.
And it says that it runs from the period starting on the day after the day payment is due. Where do we find out when payment is due?
That, my lord, is at Regulation 71.
Is it?
You go back to page 16. So, payment in full, the amount of still payable in respect of charitable development is due in full on the intended commencement date if, and then 71(2), where the collecting authority determines a deemed commencement date, which is what happened in this case, the amount of still payable in respect of that chargeable development is due in full on the deemed commencement date. So if you commence, in effect, you start to pay interest from that particular point, which is why I took you to.
Even if there's no liability notice in being at that time.
Well, if there is no liability notice, then you may be charged subsequently, but there is no other way of charging.
But the liability notice can operate retrospectively, can it, to make interest accrue from a date earlier than the date of the liability notice?
Well, it's the demand notice, actually. Sorry, so the liability notice would not refer to interest. It's the demand notice that's reliant on that. But yes, what is the practice is, and because that is the only point at which interest can be measured.
I'm just trying to understand, going back to your earlier submission about the prejudice and so forth. What exactly is the interest liability which you will or may incur? Where nobody had assumed liability to pay the levy.
Yes.
So it's not A, and there'd been no commencement notice, so it's not B. So it has to be C, but I'm not sure how they arrive or whether or how they arrived at that.
They ask when commencement is,
Yes.
and you tell them a date, and that is deemed to be the commencement date. You can challenge that, but in this case, we told them that it was the 2nd of August 2019. So in effect, if you do get a liability notice and a demand notice after commencement, that interest can still be charged back to the commencement date, because that's the commencement date. And that, in fact, is what happened with the surcharge demand notice. It took the interest and charged interest from the 3rd of August 2019.
Right. And is it 2.5 percentage points above the Bank of England base rate from time to time, so it goes up and down, or is it the rate as it was on the date when liability commences?
I have understood that to be from time to time.
I mean, it might make a difference now. That
it might well make a difference. That my figure of circa 60,000 was based simply on 2.5%, so it could well be higher than that.
Okay, thank you very much.
I'm just trying to understand. Can I just ask you about following on from that? I'm just trying to understand in practical terms what the point is that you're making. Is it simply this, that Regulation 65(1) requires that the liability notice should be served as soon as practicable after the development first permitted? That was first permitted in February 2019 for present purposes. So if they had, for example, issued the liability notice in March 2019, you would have known where you stood. You hadn't yet commenced your development, in fact, didn't commence it until August that year. And so everything would have been very crystal clear. You would have known exactly what it is that you had to pay. Yes. There would have been no interest to pay because
we hadn't started.
Right. So you say that Section 31 can't apply fairly or properly in this case because the outcome for this applicant would have been different if things had been done according to the requirements of 61(5).
Yes.
That's a simple submission, isn't it?
Yes. Thank you, my lord. Yes.
And I just wanted to be clear that I've understood it.
No. Yes, my lord. That is precisely what I'm saying. Is that it would have been better if it had come earlier, and indeed that we wouldn't be in the position where we don't know whether and if and when interest may or may not be charged, and whether surcharges may be imposed. They certainly have the power, and we don't have.
The prejudice takes two forms, I think, on this analysis. One is the basic uncertainty of not knowing in the absence of a notice being served, and the other is that if interest rates go up, then your liability is higher the later the notice is served. That's a true analysis, is it?
Well,
so you say those.
Yes,
I don't want to get
done
this
a very basic, but yes,
wrong.
Clearly, currently, there are issues that increase that potential.
Yeah, well, I suppose at the lowest you would submit that at the very least the court cannot be confident that there is no prejudice.
Yes.
Is that right?
Well, we certainly say that especially given interest is mandatory. I know that the council isn't charging it, but it is something that they can say, well, we have to. And indeed, it was recognised even when the COVID regulations came in and said, in effect, be understanding to small developers. They said, but you can't do anything about interest. It can only be about the discretion as to surcharges. So it was recognised by the government that that interest is a thing that is required by the regulations, and they haven't given the councils power, despite the fact that they clearly use them at times, not to charge it.
I mean, the prejudice of the basic uncertainty of not knowing would arise if there were no background, but perhaps is tempered by the fact that in this case you always did know that there was going to be a liability to the levy, and you had assumed liability for it. It's just that nobody picked up on the fact that there needed to be a new liability notice because of the change in the operative planning permission and the floor space point.
Well, my lord, that may be so, but it is not the appellant's fault that the liability notice came late, and it certainly, we say, is prejudicial that he faces circumstances where he's being penalised for that, in effect, because the liability notice came well after commencement.
Yeah, that may be right, but may be right.
I mean,
the council is on risk if it delays the service of a liability notice. The risk it faces actually is a challenge for claim for judicial review, because the Act doesn't provide a statutory route.
Yes.
But any council should be alert to the reality that if the planning authority, usually itself, has granted a Section 73 permission which increases the floor space and thus value of the development, the statutory scheme requires a new notice.
Well, the other thing, my lord, is that is all information that the council had. It wasn't reliant upon the appellant to remind them or explain to them that there'd been a change in floor space.
No, but the liability is ultimately a matter of arithmetic, not necessarily very straightforward arithmetic, but there's a formula for it.
Yes.
And as it were, anyone can do that.
Yes.
So the developer, I don't mean
yes.
in this case, but the developer will know what his liability is going to be if he does the calculation.
He should, yes. Or he can work out what it is, yes.
So it's not as if the arithmetic may be somewhat convoluted, but actually it's available and known.
Well, my lord, yes, in terms of the SIL and potential instalment plan, but the prejudice, we say, arises because of other things.
Of course.
So we have to, I mean...
Yes, no, but I'm simply, as it were, tailgating my lord's question about uncertainty in the particular circumstances of this case.
Yes. Well, we certainly would submit that it is uncertain, and we are potentially to be asked to pay more than £60,000 or around about £60,000.
Yeah. Anyway, you've made that submission very clearly.
On your case, as I understand it, once the liability notice is late, not served as soon as reasonably practicable, it's late forever. It's incurable because there's nothing you can do. But the example which was discussed a little while ago of, say, planning permission in February, development's not going to commence for some months, and the council serve their liability notice in March, well, that might be all right, but that's as soon as reasonably practicable. But suppose they don't serve it till April or May, and then they're liable to the argument, well, you could have served it in March. You haven't served it as soon as reasonably practicable, even though we're not going to commence development for another few months. You're still late, and you can't have any SIL payable. Now, doesn't that just illustrate the importance of the quashing remedy under judicial review being the appropriate route to challenge lateness, not going off to the inspector, and that it is a discretionary remedy.
Well, my lord, certainly judicial review is an appropriate remedy here. What I was going to take you to when you were discussing about,
but it is the remedy because it is discretionary, and it is a remedy which only a court can properly give.
well, my lord, yes, we being the appellants, were in a position where the council did not accept that. We were starting from the base case that it didn't accept that and wasn't telling us that it acknowledged that there had been a late service of the liability notice. Those were not the circumstances that the appellant was operating in, and therefore.
I'm sorry, I don't find that a very convincing argument, because I mean that's the nature of litigation. The other side doesn't tell you what you assert to be the case. So if it is a dispute, you bring it to the court.
Well, my lord, of course I accept that, but of course the circumstances that I pray in aid is that the appellant didn't necessarily want to go down, or didn't understand that this notice was, or serving it at the time that it was something that he could have challenged. I mean, that is where we are.
I do understand that, and you've made that submission very clearly, if I may say so. But one thing I'm afraid still having difficulty in understanding is why I think it's still the case that you have never asked for an extension of time, or set out in evidence why you should be granted an extension of time. Because you accept, for example, that one of the remedies you're seeking is a declaration about the 2020 notice.
Well, to that extent, we say we have challenged it, but the...
Yeah, but you haven't ever asked for an extension of time, because on any view, if you are challenging the 2020 notice, the outside time limit was 3 months from then.
Yes, ma'am.
But is it right that you've never actually formally asked any court to grant you an extension of time, or explained why you should have it?
We did.
You did?
On a very summary basis.
Right.
And it is in our skeleton arguments, but it was on the basis that if it's necessary, that we ask for permission to extend time to challenge that. Hence my submission that there were good reasons why that notice was not challenged in the first place by JR.
And that's in the skeleton before this court?
Yes, madam.
Right, so can we just get the reference, just for our note? We don't need to look at it at any length.
And my lord, I did seek it before Mrs. Justice Lang.
Yes.
Sorry, it should be at the end.
Yeah.
It's the very final paragraph, is it?
It's at Roman 3 in paragraph 105. Is that it? Is there any?
Yes, my lord.
Is there any previous argument to that effect in the body of the skeleton argument, as it were?
Paragraph 2 and 7.
Paragraph
Yes.
2.
I was looking at the summary of the complaint.
Oh, yes.
Yes, my lord, paragraph 2.
Seek to challenge out of time.
And where do we find then the argument in substance as to why an extension should be granted?
Well, my lord, I don't deal with it in detail. That is correct. I accept that
Okay.
criticism, as it were. But
It's not criticism. I just wanted to. I just wanted to know.
Well,
that's all.
The submission that I have been trying to make throughout is that there was a good reason why, because and then went down the 117.
I think the substance of it, as developed in your submissions, and I want to make sure I've written it down correctly. you said to us that what I wrote down was that the appellant did not recognise what that notice meant, you said, and you also said, you also in answer I think to my question confirmed that at that stage the appellant didn't have the benefit of legal advice, and by the appellant I took you to mean both Mr. Brathwaite and the company itself.
Yes, my lord. I mean, I do deal with it to some extent within the skeleton page, the paragraph 29, when
Right.
but that's in the context of waiver, which is where I submit out that
Yeah.
the issues are.
But you'd invite us to take that into account as well.
Yes,
All right. Thank you very much.
my lord, just in terms of a point that my lord Mills was raising, which is the question of the flexibility, and could I just take your lordship's attention back to Trent, which begins at page 221, paragraph 67 on page 224. So what Mrs. Justice Lang in Trent says, that obviously Regulation 651 imposes a mandatory requirement without any provision for extensions of time. Time starts to run from the date on which a planning permission first permits. The phrase "as soon as practicable" gives an authority some flexibility. For example, if the recipients are not readily identifiable, etc., or if there's an administrative backlog. But in light of the statutory scheme and its purpose, the expectation must be that any delay would be measured in weeks or months, not years. I consider that the absence of any provision for extensions of time, obviously I'm dealing with those extensions of time, not the one that for my appeal, was deliberate to ensure that authorities could comply with the duty in a timely way. She goes on to deal with the fact that the council said that it was unfair because this could in fact not be cured, although the collecting authority, this is paragraph 68, may subsequently issue a revised liability notice. This power only enables it to amend or replace an earlier valid liability notice, one which had been issued and served under para 8, and para 8 which provides that a subsequent, served under 651, para 8 which provides that a subsequent liability notice supersedes an earlier liability notice, also envisages that a valid liability notice has previously been issued. That is not the case here. And then paragraph 69, she deals with the point that it suggests it's unfair and contrary to the civil regulations to invalidate a liability notice because of that failure. Mrs. Justice Lang concludes, however, there are many instances in statutory schemes and legal proceedings where parties are permanently time barred because of a failure to comply with the deadline, whether in the scheme itself. So that's the those are the principles she applied to meeting that.
Yes, well, that doesn't really meet the point that as soon as practicable is a somewhat uncertain phrase, and there is, if not always, then very often going to be scope for the argument you could have done it earlier. I think the other point is that when she says there was no previous valid liability notice, she's talking about the draft 2017 notice, which was never even served at all, as I understand it. She's not, or is she,
yes,
talking about something which has been served, but was not served as soon as reasonably practicable.
But yes, my lord, that is the one that never even got out of the door, in effect.
Yes.
But she does conclude that in those circumstances, obviously the subsequent 2019 notice that she refers to was.
She does say if you're late and it's quashed, then you're late forever.
she deals with that at paragraph 61, the failure to issue and serve a valid liability notice of the claimants within the prescribed time.
Yeah, the effect of a quashing order in those circumstances is not to reset the clock.
Yes.
Time is not reversed. Or
And yes, my lord. Sorry, paragraph 85. He firmly says the regulations do not contain any provisions to save a non-compliant notice.
Well, that needs to be read in its context, doesn't it? She's not saying that you can't use 65(8) to remedy a non-compliant notice, is she? Is she saying that?
No, my lord. I mean, what she's concluding at paragraph 84 deals with, again, the importance of the liability notice.
Yeah, I mean, the question might arise, and we haven't yet asked it, what's the point of regulation 65(8)? Do I mean 8 or 5?
8's the one that ceases to have effect, and 1 is...
No, sorry, 5.
5 is the revised liability.
Yeah, what's the point of that provision? What is the point or purpose, if you will, of that provision?
Well, when things change, a liability notice doesn't necessarily have to be reissued. So if there's a slight change to the person who's the relevant person.
Right. So that it would be apt to deal with the situation that we're dealing with here. I mean, suppose there was failure of service, and they wanted to put that right. This is not this case.
Yes, yes.
They'd served it. Through acting in perfect good faith, they'd served it on the wrong company, or the company at the wrong address, or something like that. And they just wanted to put that right. They can use 65. I do mean 5, I think. To put that right, can they?
Yes, I mean, the reason I'm pausing is because obviously, if the notice is already late, you've got another problem. But if the original notice was served in time,
Well, leave late for the moment. I'm just focusing. There are 2 errors here.
Yes.
One is lateness, and the other is wrong person served. Let's focus on the second for the moment. You're accepting that 65(5) can be used to put that right. I'll use ordinary English.
Yes.
Put that right.
We've never suggested that part of the...
But you say it can never be used to put right a late notice.
No,
because you can't use the at any time provision to reset the clock.
No,
Right.
In a sense, that may provide one answer that you would give to the section 31 point. That if the error of law which has occurred is precisely that it's been issued too late, then if you imagine a counterfactual world where that error has not occurred, which is the premise of section 31, then in a sense it's a nonsense, you would say.
Yes. You can't possibly say that, yes.
You can't say there's no impact on, it makes no substantial difference to the outcome for an applicant when the very complaint you're making is the lapse of time.
Yes.
Is that how you put it?
Yes, my lord. I would put it that way. My lord, obviously section 31D is the same relative provision, so I'm not going to should you decide to grant leave, the same issues apply, that the opposition would clearly be substantially different.
Yes. Right.
My lord, I'm very happily reminded by my instructing solicitor that there's a witness statement from Mr. Brathwaite which explains why he did not challenge the 2020 notice.
Well, we make it clear that we shall read that witness statement with care.
Thank you very much.
And make sure that we've fully absorbed its content.
My Lord, if you'd like a reference, it's the very last document in the supplementary bundle, page 196 to 200.
Thank you. Pages 196 to 200. Well, we undertake to read that with care in the light of what you've submitted. Thank you very much.
My Lord, those are my submissions unless I can assist you further.
Thank you very much indeed, Ms. Cahoon. Thank you. Yes, Ms. Townsend.
Please, Your Lordships, my case in a nutshell, as you'll be aware, is that grounds for this claim arose in June 2020, on the 30th of June 2020, that Mrs. Justice Lang was right so to find, that Mrs. Justice Lang was right to identify that an application for an extension of time to challenge that notice was required in this case, and that none had been made. It's a little surprising that way that the application for an extension of time is put in the skeleton argument, and indeed orally, if it is necessary. So we're still not seized of an application for an extension of time, still less any detailed justification of the lengthy extension of time needed in the evidence before the court. And so it was and remains my submission that for those reasons this claim really doesn't get off the ground. But I will, in my oral submissions, go into the circumstances of the breach of Regulation 65 and the response to it by the appellant and the period of time since the 2020 notices were issued, as well as the Regulation 65(8) point on ceases to have effect.
Right.
But before I do, may I just pick up a couple of sort of ad hoc points? First, a point made by my learned friend on the question of prejudice.
Yeah.
She took your lordships to the instalment policy, which is right at the start of the supplementary bundle.
Yeah.
I wonder if I could ask your lordships to take that on.
Yeah.
It's tab 1. And the instalment policy itself is set out in paragraph 2, which begins at page 6 of that policy. And it's a small point, I just take your lordships to it because we see from 2.5 and the bullets thereunder, 2.5 is at the bottom of page 7, that the instalments policy can be used by anybody who assumes liability for SIL as part of any future development across the district. However, the option to pay by instalments will be removed in the following circumstances, and that is if no commencement notice is submitted and where nobody has assumed liability, and again it can be lost if payments are not made on time. And the reason I mention that is, as your lordships will recall, in this case no commencement notice was served and no individual assumed liability. So if learned friend is relying on the loss of the right to an instalment policy in her submissions, she needs also to persuade the court that had a timely liability notice been served, her client would have assumed liability and served a commencement notice and paid the instalments in a timely way. There's no evidence to support that. In fact, your lordships may think, in the light of the full history of this matter, that any one of those things just might not have happened. So just small point on the instalment policy. Also a point, my Lord Justice Singh asked my learned friend about the enforcement of payment of SIL. From my learned friend's response, I'm not sure if it's clear, that Regulation 66 provides that the amount charged, the chargeable amount as it's referred to in the regulations, is a local land charge. Regulation 66 is at page 53 of the authorities bundle.
Just a second. Yes.
So that is the normal way in which
66.
66.
Sorry, I'm being slow. It's my fault. I understand it's a local land charge, and so presumably it'll appear on the register.
Indeed.
And it binds the land, presumably.
Indeed.
Yeah, I understand that. But actually, physically, if the local authority wants to get its hands on the money, how does it actually extract the money?
Yes, and that would need to be through the courts as a debt secured by.
Right. Now, please don't take this out of order, but at some point I would like your assistance with the question I also put to Ms. Colquhoun, which is that if the local authority does sue for the money in an appropriate court, on your submission, can the person sued raise by way of defence that the liability notice and the demand notice are not valid and therefore the debt is not owed for that reason?
Yes. So my preliminary answer to that is I would consider it very unlikely that defence could be raised, because as my Lord Justice Males has indicated on a couple of occasions, the remedy is judicial review, and if a liability notice in a coherent statutory code such as this has not been challenged by judicial review, it would be surprising if the courts entertained an argument that it was vulnerable to that defence.
That may be right. That may be right, but that was the argument that was run and succeeded in Wandsworth, London Borough Council and Winder in 1984. So shortly after O'Reilly and Macbeth, the House of Lords said that certainly in that context, somebody was not precluded from raising validity.
I will of course take notice of the point and
Yes.
look at it.
I'd agree.
Given, I think I won't take time.
No, thank you. That's very helpful.
Yeah, you may want to reflect on that over the adjournment.
Yeah. And also a point raised in discussions with my learned friend relates to the scope of Regulation 117 and the points that can be taken on such an appeal. And 117 is at page 78. It may be useful to have it open, but
Yes.
it would be my submission that.
Well, let's just get
Yes,
that in front of us. Yeah, there it is. Yes.
So there are the three clear statutory grounds to appeal a surcharge. The first, that the claim breach which led to the imposition of the surcharge did not occur. Well, that strikes me as, and in my submission, is a question of fact, whether the allegation that underpinned the surcharge, that the reason for imposing the surcharge was factually correct or incorrect. The second ground, again, speaks to a set of facts which don't include that the notice was served late. But might include, let us imagine that the judicial review in this case had been brought promptly after the 2020 liability notice, but had not resulted in a remedy before the surcharge was imposed, it might be that could be related to an expectation of the liability notice being quashed. But it's not, as your lordships have indicated already, it is simply not the job of the inspector and not within his jurisdiction to express a view on the validity of the notice which was the forerunner of the surcharge. And the third, that
So-
the
Well,
surcharge
that
has
wasn't a
been-
point taken.
I'm sorry.
That wasn't a point taken before the inspector. You ought not to be doing this.
No, I don't believe it was. I can check the appeal submissions of the council. I wasn't involved at the time. But the arguments were founded on the facts. The council was saying we acted as soon as we reasonably could in the circumstances, and the appellant was saying you served it late, and therefore we shouldn't have to pay the surcharge. Neither of the appeal submissions talked, I don't think, about quashing.
No. But the argument we served it as soon as we could is irrelevant if all they need to say is we served it.
Well, yes, they were meeting.
Which is the submission you've just made to us.
Yes.
Okay.
Can I just ask you, Mrs. Townsend, if you had disagreed with the inspector as an authority, could you have sought to challenge it either by way of appeal or otherwise?
Only by way of judicial review, and in the authorities bundle there are a few judicial reviews of Regulation 117 cases. I think Heronsley.
Oh yes,
one.
yes, I recall.
Sorry, I'm so sorry to add to the questions. Just this further one. I didn't get a note of what you said it might include. You said it can't include late service, but it might include, and then I wasn't quite sure what you said it might include.
Yeah, I was rather dangerously speculating on a set of circumstances which are factually complex and not the ones we have before us. But what I was positing was this, my lord, that a judicial review had been brought promptly of the 2020 notice.
Yeah.
The council had ignored that, as they're entitled to, since until there's a remedy from that process, the notice continues to exist. And when the instalment wasn't paid, had served their surcharge. And it might be, had the judicial review resulted in the quashing of the liability notice, then it might be said, oh yes, no liability notice was served, because the effect of that remedy is retrospective, as has been discussed earlier. So it has the effect of rendering, so to speak, void ab initio.
Yes, but might include. I've written down, but might include circumstances where the notice was quashed.
You might, yes.
Yeah, I did write.
Depending on timing.
Right.
But it was no business of the inspector to rule on validity. And to be fair to the inspector, I don't believe he intended to. I believe the inspector, if you read his decision fairly and as a whole, saw the surcharges unfair in the circumstances, and saw the lateness of the notice as sufficient to justify the quashing the surcharge. Now, at that point, the collecting authority has a choice. Does it go to court, take advice on the lawfulness of the inspector's decision, go to court, get it quashed, or hope to get it quashed, or does it take, as happened in this case, a pragmatic approach? The 2020 liability notice continues to exist. That is common ground, my learned friend. There is a SIL liability. It's September 2021. and the planning authority took, in retrospect one can see it plain as day, a pragmatic approach. They set the clock to 0 and charged Sill as at that date with no interest. And to just make that absolutely clear, I will go to, I will take your lordships please to those notices, the notices that are challenged in this claim, and they are right at the back of the core bundle. It's tab, the last tab, tab 16, and there are 4 of them. There's 2 demand notices and 2 liability notices.
Yeah.
First, picking up on a point that Lord Justice Lindblom made to the learned friend, yes, it was possible to remedy the question of who was served. And your lordship will see that a liability notice was correctly served on Mr. Brathwaite. That starts at page 184. Served at his address. The error that had been made previously was remedied in this notice, in that Mr. Brathwaite was served at his address. And there's the liability notice setting out. It is slightly different from the previous notice because if your lordships look at page 185, it's exactly the same in terms of the amount charged, and it includes, it identifies separately the residential charge for the extra floor space that was permitted in 2019 at 3.78 square metres, top of page 185. If we run through that liability notice, we see at page 186, second paragraph from the bottom, as development has commenced, payment is due in accordance with the demand notice of the same date. So we'll go to that to see when the Sill is due. And consequences of non-payment warns of surcharges and so forth. If I can take your lordships to the demand notice now, the easiest place is page 177, which is the front of the tab.
Yeah.
And a demand notice was served on Mr. Brathwaite as well. Date issued on its face, 17th of September. Date of intended or deemed commencement, 2nd of August. Over the page, at paragraph 4 on page 178. The outstanding amount identified because there had been part payment, noted at paragraph 8. Payments made to date over page 179, acknowledged. Rights of appeal pointed out. And then 182 deals with questions of late or non-payment. Oh, sorry, I'm so sorry. So
It's the top of 179 you want, isn't
when
it?
payment is due.
Well, that's 179.
That's 179, immediately under payments made to date.
Yeah.
I'm obliged to. Due immediately. In other words, this notice is making it very clear that the appellant's failure to assume liability, failure to serve a commencement notice, failure to pay in August 2019, that has been put in the history books. We're starting from scratch in September, and we demand payment now, and that late or non-payment, failure, this is page 182 at the bottom, then there is the warning about interest.
If I understood correctly, Ms. Colquhoun accepts that, but says that the council would be able to change its mind, and one wonders, therefore, I suppose, what, if any, comfort you can give about that.
So that is the first time that has been indicated as the basis of any prejudice. It's the risk that the council arbitrarily changes its course of conduct since June 2020, because no interest was charged in the original 2020 notices. An instalment plan was offered, whether because of COVID, whether to be flexible, whether in recognition of its own failings, the records do not say, and frankly, doesn't matter. The course of conduct that the council has pursued since discovering that that a new liability notice was needed to reflect the change in floor space of 3.84 square metres, has always been to take a pragmatic and, if I can put it this way, a fair approach to the appellant. Now, the idea that they could suddenly serve a notice that backdated interest to August 2019 and not be told that there was a legitimate expectation that they wouldn't do that, not be told that this is inappropriate for human rights reasons apart from anything else, is fanciful. Now, I don't want to make Malone and Friends' case against such an eventuality for her, but this is a point made late and is in reality without substance.
It is in the skeleton.
Oh, well, then I stand corrected.
I think, isn't that what paragraph 100 says? Perhaps I've misread it. Page 24. Oh no, so 48, 24 internal.
Paragraph 100, I didn't understand. Yes, it refers to surcharges, but...
Well, it talks about imposition of interest, including the period between commencement of development and receipt of any liability notice.
Oh, sorry, I was looking at 101. There we are. It is there. So, but it's dependent upon a change in course of conduct of which there is no evidence.
But forgive me. As I understand the appellant's argument on this point, it said that this isn't a matter for your discretion or the creation of a legitimate expectation. What I think is said is that it's a matter of law, that Regulation 87 makes it mandatory. Now that may or may not be right, but if it's right, then why does it matter that you have so far taken the stance that you won't pursue it? It's a matter of you're actually under an obligation to change the interest.
I can't gainsay that point. It's one of the challenges of the regulations.
Yes.
And as a collecting authority, either one does what the letter of the regulations requires and then concedes a judicial review based on human rights grounds, or one tries to use the regulations in a way which is sensitive to the actual circumstances which apply.
Yes, it did occur to me.
Which were not ideal.
No, I understand that. That's a very fair response, if I may say so. Thank you. But it did occur to me, and it may be something that you may wish to take instructions on. That the Regulation 87 is, of course, in secondary legislation, and therefore.
I'm so sorry.
Sorry, Regulation 87, which is apparently mandatory, is itself secondary legislation.
Yes.
It could not override the Human Rights Act.
Yes.
The obligation which is in the Human Rights Act is in primary legislation.
Yes.
And this may be what the inspector was hinting at when, in his closing remarks, he said that although I can't stop you charging interest, you may just want to, I paraphrase, you may just want to think carefully about pursuing interest because of Article 1 of the First Protocol.
My lord, that was front and centre in my mind when I first, as my interpretation of the demand notice that I saw. So I must be careful. I haven't been told that is what the council was thinking. But when I saw the demand notice did not charge interest, I made the connection with what the inspector said, and indeed between what the inspector said and Mrs. Justice Lang held a little earlier in the same year, as it happens, in 2021, in the case of Trent. And so this is an imperfect situation. The summary grounds of defence admitted front and centre that the 2020 notices were issued in breach of Regulation 65. The argument that they were served as soon as practicable is a boat that sailed. We accepted the implicit finding of the inspector that our arguments that the notices were served as soon as practicable didn't hold water. So that being the case, though, as I make clear in my skeleton, and it is just the smallest bit frustrating that this doesn't seem to be acknowledged by my learned friend, there's a very big difference between admitting a breach of regulation and admitting that the notice is not valid. And I would leave your lordships looking at the time with this point. Mrs. Justice Lang herself looked carefully at the significance of the breach for the individual when ascertaining whether or not the breach of regulation rendered that notice invalid. And it's my submission that the notices remain valid unless quashed by this court. I've got a paragraph reference in my skeleton to
Is it paragraph 43?
It is indeed.
Right, well, we shall remind ourselves of that over the adjournment. Thank you very much, and come back at 2:05, please.